So I'm going to discuss a little bit what indeed the European Data Protection Board stated in its opinion, and did it state that we have to come up with another legal ground or basis under GDPR for clinical trials. So first of all, I want to just discuss the aim of the clinical trial regulation versus the aim of GDPR. Then seeing how those both regulations need to be applied versus one another. Is it together, or and then make sure that we discuss the legal basis as addressed in the opinion by the EDPB. And then I wanted to discuss, as you probably know, that legitimate interest was actually given as a sort of alternative basis. Does it really would work? And also then, as a last point, I want to discuss some technical safeguards which could help actually with alternative basis. So it's just to be noted that, of course, the aim of the CTR is ensure a greater level of harmonization of the rules for conducting clinical trials, this throughout the European Union. The aim of the GDPR, it's a different aim of course. GDPR is there to protect individuals with regard to the processing of their data and to have harmonized rules with regard of free movement of such data. This is very important, and that will also explain the difference in how the EDPB approached the consent as a basis throughout their opinion. But you see that there is a different aim, and that also means that it can really lead to a different interpretation of the relevant provision. The EDPB once stated, but I think that was actually very clear, that both legislations and regulations could be applied simultaneously. The CTR is a sectoral law with specific provisions and no derogation whatsoever of the GDPR. So very important to know, and that will be really the basis of the presentation. In order to have a legal basis, you have to have a legal basis under CTR, the clinical trial regulation, but also under GDPR. And I did hear really interesting talks and presentations this morning and even this afternoon on how to interpret that informed consent, as CTR is actually giving you that basis. So what this presentation, and I just want to make sure that there are no misunderstanding, is we're not saying that with clinical trials, therefore informed consent under clinical trial regulation cannot be applied. I agree that it must become much more a process rather than just something that happened in one moment of time. But we're not touching that. We are really looking then next to that. What can we rely upon under GDPR as such? So just in order to know, it's and I really wanted to stress that. So by really working with the informed consent under the CTR, we really have an ethical foundation, that it is really there in order to protect the human rights and the dignity of human beings. Where GDPR, in order, well, if we see the GDPR, it does also has legal and ethical principles in there, like data minimalization, also their principles with regard to transparency, with purpose limitation, data retention, and so some of those principles have also a real, the integrity of data have a real ethical foundation as such. Now, with regard to the legal basis, the EDPB stated that they saw that with regard, first of all, to primary use of clinical data or medical data being used in a clinical trial setting, that they saw two different operations, two different types of uses. The first use, well, they said that, of course, the first use was the one related to all the research operations, and the other one was with regard to the protection of public health, and that more has to do with regard to reliability and safety regulations in regard to clinical trials. And then they also discuss the secondary use, but we will come back on that. So with regards to the primary use, what is the legal basis in order to be able to process special categories of data within a clinical trial under GDPR? And there are actually two scholarship, but I think the EDPB, along with the other authorities, actually settled the matter whether you have actually, for the special categories of data, you have in Article 9 different legal basis. So what is the GDPR saying? It says that actually special categories of data cannot be processed unless you fall within one of the exemptions as given under Article 9.2. That's very important to also note, given that it first comes from a prohibition and then further on there are exemptions. We are in exemptions regulation or rules, which means that there is a very strict interpretation on that, and there is so no much room actually for interpretation. Now, then the question was asked, does Article 9 is a sort of lex specialis? Is it a sort of law that provision that supersedes the normal legal grounds in Article 6? But the EDPB and the other authority said that both of them are actually to be used cumulative, that if one of the exemptions of Article 9 applies, then you still have to define another your legal basis under Article 6. Some of them are quite easy to actually combine, so they really work together, and it's not a Article 9 is not a lex specialis provision over Article 6. Just to know what are the Article 9.2 legal basis, you have explicit consent, you have necessary of processing the data within employment or social security context in order to protect the vital interest, which is, by the way, one of the bases that can also be used today in order to fight the COVID-19 crisis, as it is stated in the recitals explicitly that by actually fighting against a worldwide or a European epidemic actually is a basis, or you have a basis even to collect or process special categories of data. The legitimate activities which appropriate safeguarded by certain foundations, then even data that is made public by the data subject. I'm just going to say substantial public interest, of course also legal claims, but of course also the ones in E and J, public interest in the area of public health, which is also a basis that now in the COVID-19 crisis can be used as scientific research purposes. The basis of 6 are, there are only 6 bases, but there the provision is not a prohibition with exemptions. It does say that processing of personal data is only legitimate if you have a basis. So really different because in practice, of course, you always need then to have a basis in order to process the data. But the fact that Article 9 really stipulated as a prohibition makes it an exemption rule, where here in Article 6 it's not, and you have more room for interpretation. But of course not if combined with Article 9, because then of course the exemption rule will supersede your room for interpretation. It is based on consent, and I will come back on the consent, or the performance of a contract, the compliance with a legal obligation, to protect also vital interest, or if it's necessary for a task carried out in the public interest, or then the last one, legitimate interest pursued by the controller or third party. And now let's look at the legal bases that under GDPR, the EDPB put forward in order with the primary use. With regard to the safety, they actually referred back to the clinical trial regulation and said, yeah, you have their informed consent, but you also have safety reporting obligations in Article 41 to 43, which actually means that you have a legal basis in order to process that data. It is done in the public interest of the area of public health, and you have a legal obligation because you can really refer to the articles in the CTR. So there is no problem under these legal grounds to actually process medical data for the purpose of safety as such. Then with regard to all the research operations, the EDPB said, of course, CTR gives you informed consent. I'm sorry, I forgot to mention that this is, of course, Article 28 and further that actually gives you the basis. But then they say GDPR can give you three other different legal bases which you can rely upon in relation along with the informed consent of the CTR. It is explicit consent under GDPR, or it's the performance of a task carried out in the public interest, or it is a legitimate interest. If we then look to explicit consent, and that definitely comes along with some of also the principles or one of the, I think, the guidelines Laurence provided us. But under GDPR, there is also from the Working Party 29, a very, and there are guidelines on how to interpret consent under GDPR. It must be freely given, and we will come back on the freely given. It must be specific, so that also relates to the purpose limitation. You have to be purpose specific in order to really say to what you use your, for what purposes the data collected will be used. It must be informed, and that is really going together with one of the main principles of GDPR, that is transparency. And what we see with a lot of still today, I think if you go to, and I know it's outside clinical trials, but for example, the web shops, a lot of them are still referring, and it's, yeah, it surprises me still. For example, if you then make an account or you purchase something, they're just gonna say, I accept the privacy policy. And when you click on the privacy policy, it gives you a link to the entire privacy policy. That is expressly stated by the European authorities that does not work as an informed consent. So, and I think that also coincides with a number of the points raised earlier today. Yeah, if really the notion of informed consent is that at the moment you want to consent to something, you really have to have a notion of what, who is the data controller, for what purposes your data is being processed, for how long. There really must be a sort of, what we always say, a summary. So we believe, for example, and I'm just giving now an example, not really within the health, although we also apply it on mobile health applications, but we provide with, if we advise our clients, we really provide them with a summary of the privacy policy, where, for example, if you hover over the privacy policy and you go over them, there is a little pop-up that appears, and in that pop-up you have a what we call a 2-second summary of the privacy policy that actually gives you the main elements in order to really have an informed or be able to make an informed decision. We then also make our privacy policies that we give them a 2-minute summary first. It's about 2 minutes, whatever, but it's a 1-pager then that actually really summarize once again, but a little bit more in detail, the text. And then comes the entire document, because as already raised many times, you cannot expect from people when downloading an application or using services or whatever, that they have to go through this, what is it, 8-10 page document of privacy policies. And also the European authorities really stressed on the point that privacy policies do not always have to be, or the informed consent version thereof, in writing. They also can happen in videos. They also can happen with pictograms. And I don't know if it's relevant, but for we advised a client that is making an app for children with reading difficulties. And one of our main networks in Belgium for children programs, they still have a website for the children where they have games and everything on there. And it struck me that actually when you go on the website, they have their typical cookie banner saying this website uses cookie, blah, blah, blah. And I always think, but how your visitors of your website are mainly children. How do you want to give them the information in such a language that even, of course, we do understand the cookie banner, but in given in such a way that yeah, they might not understand or have no idea what you're talking about. And we also think that even in clinical trials, it's also about patients and customers. You do not understand your customer if you do that. And so, for example, with the children with reading difficulties, it's actually a video game to enable them and to help them read. So you can imagine that giving them a privacy policy is actually would have the complete adverse effect. So we actually, or our clients, designed the video game within the video game, explaining privacy principles throughout a sort of game. So there are really ways in order to do this informed consent, but unfortunately we see that the industry as a whole is still yeah, very behind of that. It also needs to be unambiguous, and it needs to be explicit whenever you are dealing with, for example, on Amazon. There it can say click on buy, and by clicking on buy, you actually accept the privacy policy. With really special categories of data, you really must check a box or sign a document, but it must be really explicit and not in sort of implicit action as such. Now, the EDPB highlighted then two issues with consent. Consent under GDPR. So we're not talking about consent under the CTR, but really consent under GDPR, saying, yeah, okay, we have this notion of freely given consent, but will we always have freely given consent? And what about withdrawal of consent, once again, under GDPR? I will come to that. So freely given implies that there must be an absence of an imbalance of power between the data controller who asks for your consent and the data subject. And they said that, so they didn't say that in every case you do a clinical trial, there is an imbalance of power, but they say that there could be situations and certain clinical trials where an imbalance of power could actually exist. For example, if the participant is not in good health conditions, or for example, his or her child, then of course you could imagine that people are giving their consent even without really having a real choice, because there is this imbalance of power. Also, when the participant belongs to an economically or socially disadvantaged group, or when there is a sort of dependency, which is, for example, they also say in the employer-employee context, there is also an imbalance of power. So, for example, their consent could also not play. So the EDPB says that, so in some cases, and maybe they decided to say most cases, and that's open and for discussion, but that consent under GDPR, explicit consent under GDPR, could not always work and is not an appropriate basis in most cases. Then withdrawal of consent, that they also see an issue with that. Now, this really stated up front, as already said, that the withdrawal of informed consent under clinical trials is, of course, not to be confused with the withdrawal of consent under GDPR. They do not want to touch, because I also think they really don't have the real power to do so, but they don't touch the withdrawal of informed consent under CTR. because it's also made in the context of clinical trials and saying that it shall not affect the activities already carried out and the use of the data obtained based on informed consent before its withdrawal. So under CTR, I think, but I leave that also to the practitioners, I think under CTR, the withdrawal of consent is actually possible, even in practice, to comply with, which is, I think, not always, and I think the case with withdrawal of consent under GDPR. Because what does GDPR says about withdrawal of consent? It says, okay, all your data processing operations that were based on this consent remain lawful, but whenever a data subject wants to withdraw their consent, you really have to stop all the processing actions of that data subject, and you also have to delete that data because you have no more basis as such. And that really gives us problems in I think, pragmatic problems if you already reached certain results, and then all of a sudden under GDPR, a data subject will say, yeah, but I want to withdraw my consent. Yeah, then you have to actually also delete their data. What does that mean for the results? How does this affect? So in some cases that can actually become quite difficult to do so and to comply with this obligation of consent under GDPR, which you would not have if you would, for example, base your legal basis under GDPR on another lawful ground, because the other grounds might not have withdrawal of consent. But once again, it does not touch the withdrawal of consent under CTR. It is really the withdrawal of consent under GDPR that has, once again, a different aim and a different interpretation than CTR, and therefore maybe not always fit to be applied in clinical trial environments. Okay, then we are touching the other basis. So we have the consent as basis. That's what the EDPB said about consent. Then they said research could also be happening in because it's necessary for the public interest. And there they once combined again a legal basis under Article 6, along with then the legal basis under Article 9, which is on the next slide. And it says it's necessary for a task carried out in the public interest, but there must be, and that is very important, because also what we see now for example, in the fight against COVID-19, a lot of initiatives are based on this public interest, but you have to make sure that you have, as Article 6.3 of the GDPR states, you have to have a member state or a union law or another legal basis that actually, how do you say, make sure that this public interest is stated in a sort of law, which is, for example, exactly what in Italy happened. And they really had this created this member state law in order to have public interest as a legal basis. But a couple of, for example, the Belgian authorities have not yet done this. So that also could, in some cases, public interest is not always a basis as such. So that needs to be seen. And then under Article 9, there is no slide, but under Article 9 you have also the public interest in the field of public health. Then we come to legitimate interest. So the EDPB stated that there was also a legal basis. And so legitimate interest could also be a legal basis to process medical data for clinical trials. So next to the informed consent, and it's based on legitimate interest and then on the fact that it's done in a research environment. So, so as I said, leaving informed consent under CTR untouched. What is in legitimate interest? They say it's necessary for the purpose of a legitimate interest pursued by the controller or by a third party, except, of course, then you don't have legitimate interest, but we will come back on legitimate interest, where such interests are overridden by the interest of or fundamental rights and freedoms of the data subjects. Along with two possible grounds under Article 9, reasons of public interest in the area of public health, or if you pursue scientific purposes, but then you also have to comply with Article 89 GDPR, which also provides additional safeguards in order how to treat and process that data as such. Then you also have secondary use, and I think that's also touched in other presentations where you state, yeah, how do we do this secondary use? There is a legal basis. Article 28(2) of the CTR states that secondary use is possible, for example, when you also already include that in the informed consent. When looking to the GDPR, they stated that given that this happens, the secondary use, of course, the secondary use has to also be used for scientific research. It cannot be that you just sell data to commercial partners or commercial companies. It really must be a secondary use. So, for example, if you have clinical trial data and there another hospital asks, we might have it in the situation with the COVID-19 AI that the companies are now developing and the academic institutions. And we already received requests of hospitals saying, could we, after the crisis, also then, for example, have this data to further do research upon that? That would be then the secondary use that must be seen. But GDPR and the EDPB really stated that if it's done within scientific research, that it is actually, you have the presumption of compatibility, that it is done in line, that it's compatible, that purpose is compatible with the initial purpose of collecting the data. Of course, you still have to, because that is laid down in Article 9, you have to comply with Article 89 that foresees adequate, specific adequate safeguards as such. So yeah, once again, the legal basis under Article 9 are then scientific purposes of course, the public interest in the area of public health can of course be a ground under Article 9. Now, so we touched legitimate interest because it was mentioned by the European Data Protection Board. And I think when we talked with a lot of other data security, data protection, experts, this opinion was not always welcomed by every other lawyer, expert, whatever, because, and that I think comes from the fact that legitimate interest as a legal basis has been misused in the past. I definitely think within the AdTech space, for example, for cookies, but definitely advertising cookies, and in different other cases. And we have, there was also, once again, the whole theoretical legal discussion. Is legitimate interest this sort of, I always called it, if people refer it to that theory as the garbage legal basis, it is if you don't have any other of the 5 bases, well, you always have this fallback option, which is legitimate interest. And unfortunately, it was really used in that way by, in many times, where it actually is not. That was already stated by the Article 29 Working Party, which is actually the predecessor of the European Data Protection Board, really stating that legitimate interest is actually an equal ground towards the other grounds, because it also has a balancing test. And this balancing test is also something that we see coming in other legal bases under Article 9 or under Article 6. So I actually believe that legitimate interest is, if you really want to attain a legitimate interest, GDPR compliant legitimate interest, because that is very important, then it is actually not the easiest legal basis to achieve, because you have to have a purpose test. Is there a legitimate interest behind the processing? Is the processing lawful and everything? The necessity test, is the processing really necessary for that purpose. And then you have the balancing test. Does the legitimate interest, is it not overridden by the individual interest, rights, or freedom? And very important, and unfortunately we saw that that doesn't happen a lot. Sometimes only the balancing test is being done, but you need to have the purpose, necessity, and balancing test must all be satisfied. And so you also see that there are legal foundations in there, and that they are also ethical foundations in that. So, and very important to know that, for example, a legitimate interest that would violate GDPR or that would discriminate or have a misuse or an imbalance of power or misuse of power, that even if you would fail the necessity and the balancing test, you would not even be able to actually attain the purpose test. So you really need them all three to have them and have them checked. Otherwise, it will not be possible. So even if you have the purpose and a necessity test being checked, then the balancing test must still be applied, and you really have to impact the use on the interest and the fundamental rights and freedom of the data subject, where you then also have to relate to, indeed, as already mentioned, the fundamental rights principles, and even case law in that way. And there is a whole, I think it's an 80-page document from the previous Article 29 Working Party, but really that elaborates on legitimate interest as really a full and equal legal basis, where actually legal and ethical principles are being taken into account. Now, what we also wanted to discuss, or what I want to talk about, is the fact, because sometimes even when applying legitimate interest, but I don't think it only applies to legitimate interest, is the fact that you also have to build in technical safeguards, and that actually technical safeguards in a lot of circumstances can tip in favor of a sort of balancing test between the interests, which you also might be doing in other cases. And yeah, sorry,
Magali.
Yeah.
Can I just, because we're running behind schedule, can I just ask you to speed up a little?
Yeah. I just not gonna, but what I want to say is pseudonymization, because pseudonymization is, and I just want to make sure that I get a number of misunderstandings about pseudonymization out of the way. A lot of people think that pseudonymization is, if you do not achieve anonymization, well, then it will be pseudonymization. And that is not at all the case. It is really a newly defined standard under GDPR, which is a very difficult standard to achieve. A lot of people that came up or that we meet sometimes think that it's the same of encryption. Now, we just want to say with this slide that encryption does not actually protect data when in use, so when being shared for secondary purposes and so on. Very important, pseudonymization is, so pseudonymization is not pseudonymization as we knew before GDPR, but it is really newly defined under GDPR to improve not only data security, but also privacy and the privacy rights of the data subject, but also, and that is also very important within clinical trials, to maximize the value and the utility of the data. What is important, so the personal data can no longer be attributed to a specific data subject, and you must be doing that not only, the relinkability cannot happen not only by using direct identifiers, for example, a name, which is of course a very direct identifier, or a national security number, but also by indirect identifiers, like your country, your state. That's also very important. There was, for example, a Harvard study that showed that actually on the basis of, I think, the zip code, the age, and the gender, in 87% of the cases, they could re-identify the data subject only on these 3 indirect identifiers. So you see, just saying, okay, we took out the name in our Excel sheet that we are sharing with other hospitals, we took out the name, the patient's ID, and everything, or only that is enough to comply with pseudonymization. That could be the case, but in a lot of circumstances, it will not be the case as such. And so the additional information that you have to be kept separate, that so that only the relinkage to the identification of the data subject can be done with this additional information that is kept separate, is a very important standard and safeguard. It will also, better even than anonymization, help you to still, in some cases, relink to the data subject and also go to demonstrable accountability, for example, when exercising the data subject's rights. I just want to say, and then I'm gonna leave the other slides and leave to you to read, but I just want to mention that the Article 29 Working Party, for example, states that pseudonymization, under really pseudonymization, can really play a role in tipping the balancing in favor of the controller when using legitimate interest. So it is really an additional technical safeguard in order to apply legitimate interest as a legal basis. Thank you.